we'll go ahead and call the case, case number 167499, Goings versus, I'm going to try this, Giacomantonio-Snow. That's what I'm going with.
Great job.
This is a mini oral argument on the application, 15 minutes afforded to each side, 2-minute fire-free zone unless it's waived. Mr. Wyckoff, you can save some time for rebuttal. Just we ask that you keep track of it.
Understood. Thank you, Chief Justice. I'll reserve 2 minutes for rebuttal. And may it please the court, my name is Brandon Wyckoff, and I represent the defendant, Bobbie Giacomantonio-Snow. The court has an opportunity in this case to ensure that there are equal consequences imposed on both Michigan residents and non-residents whenever either one has an obligation to maintain no-fault insurance, but they fail to do so at the time of an accident, regardless of whether that obligation arose under Section 3101 or Section 3102. And I'll cut right to the chase by digging into Section 3135-2C. That's a statute that bars a driver's tort claim if at the time of an accident they're driving their own motor vehicle and that vehicle does not have the security required by Section 3101 sub 1. And I think this case really hinges on how we're interpreting those last 6 words, the security required under Section 3101 sub 1. And that statute does 2 things, 3101 sub 1. It's setting out the 3 types of insurances that make up what no-fault insurance is, the security required under the Act. And that's your coverage for first-party personal injury protection benefits, property protection insurance, and coverage for residual bodily injury liability. I like to think of 3101 as the gateway to the rest of the No-Fault Act, not just because it's the first subsection in Chapter 31, but because it's setting out 3 types of insurances that are the entire focus of Chapter 31 of the Insurance Code. Anyhow, the second thing 3101 sub 1 does is it sets out a class of individuals who have to buy that insurance, or maintain that insurance, rather. And those are your owners and registrants of motor vehicles required to be registered in this state. And then 3102 comes along and defines another class of people who have to maintain that insurance. And those are non-residents who operate their vehicle in Michigan for more than an aggregate 30 days per year. And if you are that type of person, you have to maintain security for the payment of benefits pursuant to this chapter. That's what 3102 says. It links itself right back to 3101. So in this case, you have...
Can I ask a question?
Certainly.
And it's the same question I posed to counsel on a previous case, is what do we do about people who don't have licenses, who don't drive? What happens to those people? And ultimately here, do you think that most people who have a summer cottage or who are coming back and forth or staying here for the summer, I mean, do you think that most people are even aware that they would have to buy Michigan no-fault insurance? Because their assumption would be that they're fully covered in their home state, and that ultimately that notion of, well, if I'm coming to Michigan, I've got to buy Michigan no-fault insurance if I'm coming for the summer?
As to your second question, Justice Bernstein, I think 3102 doesn't, it's pretty clear that if you're driving your vehicle in Michigan in aggregate more than 30 days per year, then you have to have that coverage for no-fault benefits. I can't speak to whether every out-of-state individual knows that, but I suppose they should be presumed to know that. And I'm not sure I understood your first question about unlicensed drivers.
Unlicensed driver, a person that does not have a license, which therefore does not have no fault, how does that affect them?
Well, if they don't have a driver's license, they still could be considered a person who's driving their vehicle in Michigan. I mean, you could have conceivably an unlicensed person who's a non-resident and driving their vehicle in Michigan more than 30 days, and such that they could run afoul of 3102 still, regardless of whether they're licensed or not.
Okay.
Could you, and maybe this is a silly question, can you secure a Michigan no-fault policy for a vehicle that is registered and housed in Ohio?
I don't see any reason why you couldn't. That, I think, might be more of an underwriting question, which I might not be able to speak to and would probably vary from company to company.
That they insure non-Michigan
cars.
non-Michigan registered vehicles.
I don't see why they wouldn't, but again, I think that would vary from company to company. I'm not trying to avoid the question. I just don't know.
No, I understand,
Yeah.
but that would be a consequence, right?
It could be if a company just
of saying, I live in Toledo, I work in Monroe, I'm gonna go and drive my car on a regular basis. I live in Toledo, I reside there, I, garage my car there, I've registered it there. And if it is not possible to actually get coverage in Michigan, then doesn't that have some bearing on whether or not the statute is reasonably construed the way that you're advancing?
I don't see why, for example, a resident of Ohio couldn't obtain Michigan no-fault insurance, because the companies that do business in Michigan do business in other states. So conceivably, a resident of Ohio could get coverage from, any company that does business in Michigan, be it AAA, Farm Bureau, any number of the big companies doing business in Michigan. I believe they also do business in other states.
So they would have to sort of doubly insure their car, both where they reside and where they drive it.
I'm not sure about,
30 days.
sorry, but I'm not sure about doubling the coverage, because it seems to me that if someone has Michigan no-fault coverage, it would satisfy it would go over and above any security requirements required in the other state, which I presume would be less, because Michigan's no-fault system, the coverage requirements are so robust. I would think that Michigan coverage would be the same or greater than
Ohio
out-of-state coverage.
similarly might deny coverage for an accident that occurs out of state.
Right.
Right. Okay.
So again, I discussed 3102, and what plaintiff's argument boils down to is, well, 3135 only refers to 3101, and so because John Goings was allegedly a non-resident at the time of the accident, and because non-residents generally don't have to register their vehicles in Michigan, then because John Goings can't run afoul of 3101, then he can't trigger 3135 2C either. But that argument ignores the first thing that 3101 is doing, which is defining the three types of coverages that make up what no-fault insurance is. And by ignoring the first function of 3101, plaintiff assumes that 3135 is referring to the obligation imposed by the second function of 3101. But I think 3135 focuses on the existence or absence of the security defined in section 3101. And I think if the legislature wanted to link the second function, so to speak, of 3101 to 3135, then I think they would have structured it the way they did with section 3177, which the Insurance Alliance pointed out in their amicus brief. And so section 3177 sub 1, this is a statute that allows an insurance company assigned by the assigned claims plan to subrogate against the owner of an uninsured motor vehicle. And that statute defines an uninsured motor vehicle as one that does not have the security as required by sections 3101 or 3102. And as required by section 3101 and 3102 means it's insured in the way that the law states under each of those subsections. And I know I'm making much ado over the existence of the word as in 3177 and the absence of that word in 3135, but I think the existence of the word as in 3177 turns it into more of an adverbial phrase, whereas the absence of that word in 3135, again, focuses on whether that coverage exists or not.
But 3102 is also absent, right, from 3135?
Correct.
So it's not just the absence of as, and couldn't the argument be made that the point that they are able, when they mean to refer to 3101 and 3102, so those 30-day plus drivers, that the legislature knows how to include that in the statute?
I get that argument. I respectfully disagree with it, though, just based on the way 3101 sub 1 is peppered throughout Chapter 31 of the Insurance Code. We see this phrase, the security required by 3101, or the security required under 3101, which I think those two phrases mean the same thing. But those two phrases appear, I think, 26 times throughout Chapter 31, and they are simply shorthand reference to what no-fault insurance is. I think a good example is Section 3104, I think it's subsection 24, which refers to the refunds of surplus funds that the MCCA can reimburse, kind of like they did back in, I believe, 2022. And it refers to an insurer writing a policy that includes the coverage required under subsection 3101. So if we're following plaintiff's interpretation, that means refunds don't have to be issued for policies that were issued under 3102, since it's absent from there.
Counselor, so I sort of envision there's three categories, if you will, of drivers. There's people who are coming in but not more than 30 days, and they're not required under 3102 to have Michigan coverage. There's people who are coming in more than 30 days but who didn't get the policy, and there's people who are coming in more than 30 days but who got the policy. And I think under your reading, you would say, you know, number 1 and number 3 should be covered, but not number 2, right? Because they didn't get the Michigan insurance.
Correct, yes.
But if we read the statute to say the existence or absence of security is required of 3101, for this case, you want us to read sort of implicitly and also as required by 3102, or that it covers 3102 as well. For people who actually aren't required to get it because they're just driving through, you're also saying that means as required by 3101, and because they're not required, it's sufficient. Is that sort of the argument? So
Can you describe the type of person you're talking about again?
So someone who's just driving through isn't here for more than 30 days.
Okay.
They come once and unfortunately they get into an accident here. How does the statute play out for that individual?
That type of person they're not required under 3101 to register their vehicle in Michigan and comply with that part of 3101, because, again, the Motor Vehicle Code generally exempts non-residents from having to insure their vehicles, unless, I believe, the Motor Vehicle Code refers to a non-resident who has a pleasure vehicle in Michigan and drives it 90 days or more consecutively. But that aside, the type of person you're talking about would not have to comply with 3101 or 3102. So they would not trigger the ban on tort claims under 3135-2C.
So we don't have to read the 3101 to have any meaning for them because they're not required by 3102 to have coverage.
Right, they're not required under either 3101 or 3102, because again, 3135-2C is looking to the existence or absence of no-fault insurance, regardless of whether that obligation arises under 3101 or 3102. And that's because, again, 3101 is doing two things. It's defining what no-fault insurance is, and it's defining one class of persons who have to buy that insurance. Unless there are any additional questions, I will reserve my remaining time for rebuttal.
Thank you.
Thank you.
Thank you, Justices. May it please the Court, Bradley Perry on behalf of the plaintiff appellee, John Goings. Now, this case presents a single straightforward question, and that is, does a violation of MCL 531.02 sub 1 bar that person from recovering non-economic damages pursuant to MCL 531.35-2C? The answer is no. The Court of Appeals correctly answered no, and it reached that conclusion by doing exactly what this honorable court has long instructed, and that is start with the text, respect the text, and end with the text. Now let's start where the legislature started, with the words it chose. Now section 3135-2C says, damages must not be assessed in favor of a party who did not have an effect for that motor vehicle the security required by section 3101 sub 1. That's it. There's no mention of 3102 sub 1 anywhere in that provision or anywhere else in section 3135. Now, if the legislature had intended to bar recovery for someone who violated 3102 sub 1, it could have easily written it into that statute. At the end, it could have said 3101 sub 1 or 3102 sub 1. It didn't, and under every principle of Michigan statutory interpretation, that omission matters. Now, this honorable court has said repeatedly that we don't add words the legislature chose to leave out. When the statute is clear, the analysis simply stops there. So under the plain language of 3135-2C, the only people who are barred from recovering non-economic damages are those who are required to maintain insurance under section 3101. That is, Michigan vehicle owners or Michigan residents, and not visiting non-residents. Now, we also know that the legislature did change the no-fault statute back in 2019, and it was substantially amended, and 3135-2C was actually revised, and again, at that time, only referred to 3101 sub 1, even though 3102 sub 1 had been part of the act for decades. And that tells us something important. That tells us that the legislature had every opportunity to expand the bar to include 3102 sub 1 violations, and it chose simply not to. That choice reflects deliberate legislative intent, and that's what we're here to argue.
What is the effect, what practical effect, even if we assume your argument that of a person like the plaintiff who violates 31021 by operating the vehicle that's not uninsured in Michigan for more than 30 days? Why is that? Is it just admonition that you shouldn't do that? What is the effect of violating that statute?
As far as the effect, really it stands to no-fault benefits, so those personal injury protection benefits. Now, the purpose of 3102 sub 1 is for someone who's using the Michigan roadways on a regular basis to pay into our unique no-fault system. That is, pay into the MCCA to protect the other Michigan residents since you are using our roadways. Now, if you violate that statute, you obviously forfeit your acceptance of that personal injury protection. And a lot of the cases that were cited in here deal with those PIP benefits, and that's where they lose out. They just simply lose out on collecting from a Michigan insurance policy that allows for those PIP benefits.
Meaning somebody, obviously they don't have their own policy.
The-
But they
here,
are
well-
precluded because they don't have the insurance, right?
No, Mr. Goings is insured. He's insured by Ohio policy.
Right, but you're saying it precludes them from collecting PIP benefits.
Correct.
Who would they claim PIP benefits through? They don't have their own policy, and they're a non-resident of Michigan.
They just forfeit that right. That's what the statute's there.
But is it in fact a right? Like, are they forfeiting anything? Who would they ever claim PIP benefits from? I get that they don't get PIP because they don't have a policy, right? They don't live in Michigan,
That is correct.
and they don't have a policy. So does 3102 sub 1, you say they can't get PIP benefits, well, they weren't gonna get them anyway because they don't have a policy. Like, what is the effect of 3102 on this?
Well, the effect of 3102 is simply that. I think it's just the legislature saying that, look, if you're using Michigan roadways, you need to insure your vehicle under Michigan PIP in order to get that right to have your personal insurance protection benefits. I think it's just their way of stating, if you're using our roadways and you're using it for over 30 days, you need to insure it under PIP because that's what Michigan residents do. It doesn't necessarily bar for the non-economic claim under 3135-2C. That's simply it, because these are non-residents that you're dealing with. And simply put, I don't think it was the legislature's intent to simply say, okay, you have grandma and grandpa down from Florida who's visiting for the summer. They're driving down 75 going through Monroe and gets hit by a drunk driver on day 31. Well, that bars their claim for non-economic damages against that drunk driver simply because they insure themselves with Michigan PIP. That makes no sense. That makes no sense whatsoever. And that's not the legislative intent here. And that's why it's not included in 3135-2C for that exact reason. Now, going back to the legislative intent and the structure of the No Fault Act, as I indicated, in 2019, the No Fault Act was substantially amended, and the legislature at that time had a chance to add 3102 sub 1 to the bar under 3135-2C and simply chose not to. So in 3 other sections of 3135-2C, it also references only 3101, and those are subsections 2C, subsection 3, and subsection 4E. Now, not once in those subsections is 3102 referenced, and that is deliberate. That's deliberate by the legislature because they do not want to include 3102 as a bar for anything in 3135. So, as it stands, the Court of Appeals was correct in applying the statutory interpretation and the strict reading of the statute where it does not include 3102 as a violation or a violation for a person who either does not have insurance after driving their vehicle for 31 days and is a non-resident. It doesn't include that non-economic bar. So we're asking that you deny leave or affirm the Court of Appeals decision.
Can I ask you, just maybe I'm getting started. So assuming you're correct and that they're not barred under 3135, are they subject to the serious impairment requirement?
Oh, absolutely. That's codified in the statute. They would be subject to what's in 3135 and establish those elements under 3135 because the crash would have happened in Michigan and therefore Michigan law applies. And that is in the statute.
Okay.
Because the question goes to 2C as far as who is barred by 2C, and that is Michigan residents who fail to carry insurance under 3101. And I know the appellee indicates that really we're arguing that Mr. Goings is just, he insured himself under the Ohio policy and that was sufficient and therefore he doesn't need to insure himself under PIP. Really, it's a statutory interpretation argument because we're looking at the plain language of 3135 2C and who that applies to. Now, the security is the same, but the class of people are different. You're dealing with Michigan residents versus Michigan non-residents. And so if it was the intent of the legislature to bar non-residents, they simply would have done so by simply adding 3102 sub 1 to that subsection, and they chose not to.
Counsel, what about defendant's point that your interpretation would extend to 3135-3, that non-residents who do pay into the system now would not receive tort immunity?
I disagree with that as far as for 3135-3.
I think you're saying if you're limiting the definition, of how we look at 3101, and that statute also refers to 3101, I think that's how they're reading it.
Yeah. I mean, I guess I really don't know the interplay in terms of 31.3 versus anything else because it simply just references, again, that's a subsection that references 3101, and I don't think it would affect anything dealing with non-residents. So I don't understand how that would even be applicable to this because really the only statute that's at play here is 3135 2C and how that applies for non-economic damages. Did that answer the question as far as exposes or any follow-up?
I think you just have different views on it. So yeah.
I think that's
Yes.
probably more the stance on it.
Yeah.
Well, if there's no other questions, thank you.
I only wish to emphasize that plaintiff's argument and the Court of Appeals analysis ignore the very first function of 3101 sub 1 that I set out, which is to define what no-fault insurance is. And that gets me to another big problem I have with the Court of Appeals decision. The Court of Appeals essentially put on a set of horse blinders when they were looking at 3135 and 3101 and holding that because both statutes are unambiguous, we don't have to look any further. We don't even have to consider Section 3102. But this court in SBC Health versus City of Kentwood specifically said that a finding of ambiguity is not necessarily the only trigger by which to employ in pari materia. I simply want to emphasize that. Unless the court has any other questions, I'm simply asking for the court to either grant the application for leave to appeal or peremptorily reverse the Court of Appeals decision. Thank you.
Thank you. Case will be submitted.